Welcome. My name is Aubrey Beck, and I'm going to talk to you about product liability risks of cannabis in the industry. This is for Alvernia University's MBA 610 Legal Environment class, taught by Professor Wells. In my presentation, you will learn about product liability, strict product liability, specifically failure to warn, and warranties, specifically implied warranties. Enjoy. To date, 29 states and the District of Columbia have laws broadly legalizing marijuana in some form. 7 of those states and the District of Columbia have adopted the laws for recreational use. If you want to check your own home state, the picture to the right of your screen has each state broken down with a color-coded map. The cannabis market has been vastly growing since 2012, when Colorado and Washington legalized marijuana recreational use for the first time. Our society has finally turned to see the green in the green plant that has been highly coveted since its prohibition in the 1930s. We are now contemplating taxing and implementing state laws around this very profitable substance. California's Prop 64 measure now allows adults to possess up to 1 ounce of marijuana and grow up to 6 plants in their homes, as long as they are of age 21 or older. Other tax and licensing provisions of the law will not take effect until January 2018. As with any financially robust product comes liability, and with an ingestible hallucinogenic product comes substantial risks from product liability. So, what is product liability? It's actually a bit more complex than you may think. Our book defines product liability as, quote, the liability of manufacturers, sellers, and lessors of goods to consumers, users, and bystanders for injuries or damages that are caused by the goods. Essentially, it is a form of protection for the consumer. We as consumers have an inherent right to basic safety, so there are laws and regulations imposed that way our goods can't harm us. It is really important to note that there are no federal product liability laws. All of the product liability laws are state, and therefore they vary across county and state lines. There is also another liability called strict liability. That's defined as liability without fault. This is where it doesn't matter how careful the business is. If there was a defect in the product that caused harm, the business is automatically liable. So what about recreational drug use? Strict liability affects cannabis in one of the 3 types of defects. In particular, we're going to talk about failure to warn. Failure to warn is a marketing defect that is very tricky with substances, as each person reacts differently. The explanation for a failure to warn defect in strict liability is when a company failed to include proper instructions, or when they failed to warn consumers about potential dangers relating to the product. The cannabis customer buys a product commonly known to have an intoxicating effect, very similar to alcohol. Currently, California does not place a liability on liquor stores or establishments that serve alcohol, unless the person served is an obviously intoxicated minor. As a society, we do not hold product manufacturers liable unless that product manufacturer places an unreasonably dangerous product on the market. So, how do the cannabis companies plan to warn customers about potential risks on a drug that has been illegal for almost the past 90 years? Let's take a look at the current risks with cannabis and figure out what solutions we've already come up with. One trend that has emerged and taken the world by storm is cannabis-infused edible products. Infused products account for the majority of the cannabis market and is expected to form the basis of product liability lawsuits. Similar to alcohol, cannabis may take significantly longer to affect customers if eaten versus inhaled. Consequently, many customers may eat too much of it, and therefore it could lead to potential liability if it's not marketed correctly. The standard dose of THC, otherwise known as tetrahydrocannabinol, is 10 milligrams. Many consumers would not think this, but one small bite of an edible could be the full dose, regardless of the warnings or instructions provided. The article I read gave an exemplary example of this, and it helped me understand what this meant by the cannabis market. Imagine you go to a bar and you just want a glass of wine. The bartender tells you that your only option is that you must drink the entire bottle of wine. No stopping, no sips, just down the entire bottle. You might not want to drink the entire bottle, and you might not want the impacts of drinking the entire bottle, or even know what this entire bottle of wine would do to your body or your system or your mind. This is your only option, though. The same is true with some of the edible cannabis. Some customers don't know how much THC they will get of just one bite of one product. And even then, that one bite might be far more than what they expected. So how do you warn the public properly about your product when you don't know how each person is going to react to it? The cannabis industry is adopting strict dosage limits in understandable and clear packaging. They're also embracing the idea of microdosing edible products in small portions such as 1 milligram of THC. Some other anticipated product liability risks come from the widespread use of lithium-ion vaporizers, pesticides, mold contamination, misrepresentations, breach of warranty claims, label claims, and other failure to warn theories. In Chapter 12, our book touches on warranty claims and breaches. Warranties simply impose a duty on the seller or lessor. A breach of said warranty is a break of the seller or lessor's promise. If the seller or lessor breaches a warranty, then the buyer or lessee can sue to recover damages from that seller or lessor. For food and drug industry, those companies are under implied warranties. An implied warranty is defined as a warranty that the law derives by implication or inference from the nature of the transaction or the relative situation or the circumstance of the parties. In other words, by law, if a seller knows or has a reason to know the purpose for which an item is being purchased, the seller is guaranteeing that the item is fit for that particular purpose. For instance, the coffee industry makes coffee grounds for the use of consumption. Believe it or not, you can actually use coffee grounds to fertilize soil. So what happens if the coffee grounds don't do a good job at fertilizing your soil? The coffee company is not expecting their customers to use the grounds as fertilizers, and therefore they're not held liable under an implied warranty. My article makes a comparison between the risks of edible cannabis to the diet supplement industry. The Federal Dietary Supplement Health and Education Act stopped the dangerous, rapid growth of the supplement industry by requiring the supplement manufacturers to get FDA approval before marketing their supplements. The previously unregulated market allowed actors to sell potentially dangerous supplements. In 2000, the plaintiffs' bar cleaned up the industry and drove most companies out of business. There were numerous product recalls. Many of the issues that arose were strict product liability, negligence, breach of warranty, misrepresentation, unfair business practices, and fraud. Does this sound similar to the cannabis industry? It should. Luckily, the cannabis industry can still learn from the dietary supplement fiasco, but even today, we've already seen signs of the same pitfalls, such as product recalls. From September 8, 2015 to April 26, 2017, there have been 66 cannabis recalls in Colorado alone. In order to prevent this in the future, One of the learned behaviors from the cannabis industry is their progress in self-regulation. They have adopted practices of rigorous product testing, advanced track and trace programs, and creations of standards. The 2016 Gaia's Garden case is what most people fear more than anything with hallucinogenic drugs. Richard Kirk ate Gaia's Garden's Karma Candy product, and in an alleged bout of temperament insanity, he shot and killed his wife in 2014. In 2016, the children sued the company, saying that the product was improperly labeled, which allowed their father to consume 101 milligrams of THC, causing extreme hallucinations. Their claim alleges strict product liability, negligence, failure to warn, deceptive trade practice, breach of implied warranty, misrepresentation, and consumer fraud. In regards to the murder, February 2017, Richard changed his plea from not guilty to guilty. The reason was to keep Christine, his wife's family, from going to trial. He is now serving 25 to 30 years in prison. Even with vast testing, liability awareness, and warranties, there will always be risks and potential for lawsuits for consumers and businesses. My article talks about 2 famous lawsuits that have already emerged from the cannabis industry, with more expected to come as more and more states gain traction in this recreational drug. The lawsuits that have been released relating to the cannabis product liability are the Livewell case and the Gaia's Garden case. Livewell runs 9 dispensaries and is one of the largest grow houses for marijuana. In 2015 in Colorado, 2 medical cannabis patients alleged contamination of the company's marijuana by a pesticide called Eagle 20. Eagle 20 produces hydrogen gas when it's burned. In 2016, this suit against Livewell was dismissed based on a determination by the court that there was no evidence of actual injury to any customer caused by this alleged contaminated product. In conclusion, not every person who smokes or digests edibles is subject to suffer from extreme hallucinations and kill the people around them. But this does show that the drug can be very dangerous. From a legal standpoint, any business that provides the public with something we put in our body has significant risk and liability. The drug companies, from diet pills to vitamins to medicine, needs to be very cautious with their labels and with advertising. The cannabis industry was evaluated at $7.2 billion in 2016, and they are now projected to grow at a compound annual rate of 17%. By 2020, medical marijuana sales are projected to hit $13.3 billion, and adult recreational sales are estimated to be at $11.2 billion. This industry is also expected to create more jobs than manufacturing in the next 2 years. With these statistics in a slowly declining economy, I don't see the cannabis industry going anywhere, regardless of the product liability risks, strict liability risks, and potential breach of warranties.